Greetings, my fellow freedom lovers and sovereign thinkers. Thank you for doing the LL3 podcast. My name is Craig, transmitting from the beautiful swampy mangroves of South Florida. And today's date is Thursday, December 5th, 2019. Hopefully everyone had a great Thanksgiving, even though I haven't done the show in a while. Some absence as usual. It was pleasant for me. Good atmosphere. Of course, everyone's running amok on Black Friday, waiting in line. Folks need a life, man. Good grief. Fight over material things. How flamboyant it is. Looks like Kamala Harris has dropped out of the race. I wonder why. Because she sucked at her job, even as the senator for California and attorney general. Supports victimless crime laws, treats her workers or campaign staffers like garbage, or filled with exercising derision. So that's the kind of person you want as a commander-in-chief, even though she is not a natural-born citizen, because both her parents were from other countries. Can we say conflict of interest or possibly foreign influence? Always got to look at those areas. And not because she's a black woman or black Indo woman, anything like that. Her ethics were weak and pathetic. And a typical loudmouth who would like to have the country revolve around her. In reality, it doesn't work that way. And supporting victimless crime laws are nothing more than cowardly, revenue-collecting demonade that she is on the woman's actions. Nothing more. And they're all talking about 300-page information on impeaching President Trump. Laughable. Ass clown circus. Awful, stupid, lousy. Even worst Hollywood films will make it a genuine classic, a masterpiece on what these Huey and Deweys in Congress are doing. Hey, all you gotta do is listen to my show about House Resolution 660, Bill of Attainder, ex post facto law, null and void under Article 1, Section 9 and 10 of the U.S. Constitution. However, but some people like to use, well, the Republicans did it. It doesn't matter. Two wrongs don't make a right. So you can take your little gang of romper room audience and go somewhere else, because you are contaminating space. Speaking of derision, non-conforming, when I heard the show from Chris Sanhall, which she's very good, chrissanhall.com, constitutional attorney, pastor's wife, teach show, not a talk show, talked about the Bill of Attainder. It's really interesting because Bill of Attainder, even with the impeachment inquiry, goes further than that. So I'd like to take the initiative of examining Florida Statute 790.041, risk protection orders. It could be equivalent to that as well. And it's interesting because I'm like going through this. I'll give a few little examples, some examples here. Why is under that same category? A lot of us know. But people, sometimes you got a multi-prong attack. The ones that support it in Florida, including Gary Farmer Jr., the Florida Senator, and Flip-Flop Rick Scott, and all the corn douchebags from both parties are responsible for this. Fear is a great weapon. And it really disturbs me the most when people like to use that problem reaction solution And they haven't really learned the lessons of 9/11. If you haven't comprehend not to be vigilant after this horrific event, then you're a damn fool. And that's the truth. Don't worry, there's people I know that have great families. They hate this with a passion. Don't tell me I don't understand. Even March for Our Lives, you gotta call them out. Ask them how they feel being the children of the Khmer Rouge as Pol Pot, your Lord and Savior. Or Jim Jones. I like what it says here about definitions. Risk protection order means a temporary ex parte order or final order granted under this section. Of course, I talk about the petition here. Allege that respondent poses a significant danger of causing personal injury to himself or herself or others by having a firearm or any ammunition in his or her custody or controlling by purchasing, possessing, or receiving a firearm or any ammunition, and must be accompanied by an affidavit made under oath stating the specific statements, actions, or facts that give rise to a reasonable fear of significant dangers acts by the respondent. That is that same statute, section 2E, subsection 1. They give you all the details. Identify the quantities, types, and location of all firearms and ammunition petitioner believes to be in the respondent's current ownership, possession, custody, or control. That's 2. And 3, identify whether there is known existing protection order governing the respondent under Florida Statute 741.30, 784.046, or 784.0485, or under any other applicable statute. Looks like they're paving the road out here. Just to let you know, I'm at Stash, located at 109 Southwest 2nd Avenue in the heart of the Hill-Street District of Fort Lauderdale, Florida. Adjacent with Revolution Live in America's backyard. There's a little coffee shop, den bar they call it. A little speakeasy. You may hear some construction in the background, so I'm sorry about that. So I'm not gonna go through everything in this entire page here. But like it says here in subsection 3, risk protection orders here in the issuance. A, upon the recipient of the petition, the court must order a hearing to be held no later than 14 days after the date of the order, must issue a notice of a hearing to respondent for the same. Look at that. It's like a real fast track thing, right? Yeah. But if you get arrested for having a container of alcohol, or maybe having marijuana possession and so forth, they'll do the calendar call. The waiting games. They can lose your patience. They can throw in the towel. See, that's how sneaky these individuals are. So it's here on here under 1. The clerk of the court shall cause a copy of the notice of a hearing and petition to be forwarded before the next business day to the appropriate law enforcement agency for service upon a respondent as provided under subsection 5. 2. The court may, as provided in subsection 4, issue a temporary ex parte risk protection order pending the hearing ordered under the subsection. That temporary ex parte order must be served concurrently with notice of a hearing and a petition provided in subsection 5. 3. The court may conduct a hearing by telephone pursuant to a local court rule to reasonably accommodate a disability or exceptional circumstances. Okay, so it's an option. The court must receive assurances of the petitioner's identity before conducting a telephone hearing. Be upon notice in the hearing of the matter if the court's finding by clear and convincing evidence that the respondent poses a significant danger of causing personal injury to himself or herself or others by having in his or her custody or control by purchasing, possessing, or receiving a fire or any ammunition. The court issue a risk protection order for a period that it deems appropriate, up to, including, but not exceeding 12 months. So they could just babysit your property for 12 months. How's that legit under our Declaration of Rights? To say C, in determining whether grounds of a risk protection exist, the court may consider any relevant evidence, including but not limited to any of the following. 1, a recent act of violence by a respondent against himself or herself or others, whether or not such violence or threat of violence involves a firearm. How about if it was a knife? Did that count? No. Pretty biased. Exactly. 2, an act or threat of violence by a respondent within the past 12 months, including but not limited to acts of violence by a respondent against himself or herself or others. 3, evidence of the respondent being seriously mentally ill or incurring mental health issues. So they're going to go by past records, suppose. So how are they going to do that? They're going to have a search warrant and all that, or is it going to go bypass everything? Oh, there's a protection law supersedes Article 1, Section 12 of the Florida Constitution. And they talk about many multiples here, about respondent has used or threatened to use against himself or herself or any other weapons. You just go to jail if you threaten somebody. That's like a threat. Come on, give me a break. This is very conflicting other laws here, right? Of course, unlawful reckless use, displaying or brandishing a firearm by a respondent. That's number 9. That you could go to jail for that. Okay, so come on, what you got to do with risk protection order on that one? Good grief. You get a warrant for his arrest. He's accused of brandishing a firearm. Okay, you have to go through this stupid order. Because it's like right now, what they're doing, they're actually congesting themselves. When you look at this. So there's multiple here about evidence and all that, relevant information. I'm not gonna go through this in entirety, folks. I'm just giving you a little rundown. Finding some lot of very controversial, very disturbing indeed. I like to say about I think it's 3D. I think it is. Hold on, let me just continue on here. Yeah, 3D6. Okay, 6D. A person, including officers of the court, who offers evidence or recommendations relating to the cause or action, must present the evidence or recommendations. That's just a viewpoint. In writing to the court with copies to each party of his or her attorney. If one is retained, must present evidence under oath at a hearing which all parties are present. Oh, okay. In a hearing under in a hearing under this section, the rules of evidence apply to the same extent as in a domestic violence injunction proceeding under 741.30. That's for the statute. During the hearing, the court must consider whether a mental health evaluation or a chemical dependency evaluation is appropriate, and if such a determination is made, may order such evaluations if appropriate. All right. So they can show up, but there's no how you gonna defend it, right? How he has to defend himself. So that's why I call this like a really very touchy subject. Illegal practice, unlawful practice to be exact. And so we can really just look at these areas. When I'm skipping through here, I'm like, good grief. Of course, about here, G, risk protection order must include all the following. 1, a statement of the grounds supporting the issuance of order. 2, the date of order was issued. 3, the date the order ends. 4, whether a mental health evaluation or chemical dependency evaluation of the respondent is required. 5, the address of the court, which any response should be filled. 6, a description for the requirements for surrender all firearms and ammunition that the respondent owns under subsection 7, and the following statement, right here, to the subject of this protection order. This order will last until the date noted above. If you have not done so already, you must surrender immediately to insert the name of local law enforcement agency, all firearms and ammunition that you own in your custody, control, or in possession, and any license to carry concealed weapon or firearm issued to you under Statute 79.06. Florida statutes, you may not have in your custody or control or purchase, possess, receive, or attempt to purchase or receive a firearm or ammunition while this order is in effect. you have the right to request one hearing to vacate this order. One request. So, one request. So they have you in the corner like a little kid, okay? Like you're gonna get suspended, put you in a little corner without you speaking your mind. It happens to a lot of students that got suspended. They have them sitting outside, have them give them all the rundown, not hear their side of the story, and they'll suspend them. Very similar, very like government indoctrinating practice. Okay, so you have the right to hear to vacate this order, starting after the date of the issuance of this order, and to request another hearing after every extension of the order. If any, you may seek advice of an attorney as to any matter connected with this order. Greece say, screw due process, this is exceptional. And H here, if the court issues a risk protection order, the court must inform the respondent that he or she is entitled to request a hearing to vacate the order in the matter provided by subsection 6. The court shall provide with the respondent with a form to request a hearing to vacate. Hearing will be held on the date and the time noted above to determine if a risk protection should be issued. Failure to appear at your hearing may result in the court issuing an order against you, which is valid for 1 year. You may seek advice of an attorney to any matter connected with this order. So it's one of those little things here. So they go through the whole rundown about how this really goes. The termination and extension of the orders. You'll be run down in here as well. And like I said here, we'll look at that here on 6, which is subsection 3. Or subsection 6, I think it's section 3, if I'm correct. All right, let me see. I'm just going to look at this one moment. I just printed everything up here, so bear with me, my friends. It's just really mind-boggling, you know? Yeah, so 6, okay, subsection 6, in A. The respondent may submit one written request for a hearing to vacate a risk protection order issued under the section. So then after the date of the issuance of the order, it may request another hearing, every extension of the order, if any. And they give you a whole rundown here about the vacated risk order. The court shall set a date. Hearing must occur no sooner than 14 days and no later than 30 days. All right. And to here, this says here on subsection 2, that says, which is 3, subsection 6A, 2 now. The respondent shall have a burden of proving by clear and convincing evidence that the respondent does not pose a significant danger. So you're guilty until proven innocent. How constitutional is that? It's not. But I will bring that up. I'll bring it up a little bit here. Of causing personal injury to himself or herself or others by saying his or her custody control, purchasing, possessing, or receiving a firearm and ammunition. The court may consider relevant evidence, including evidence of the consideration listed in paragraph 3C. And of course, the court finds after the hearing that the respondent has met his burden of proof, the court must vacate the order. So, innocent until proven guilty. Guilty until proven innocent, excuse me. Alright, so that's very dangerous. Of course, they got holdings here, for law enforcement agency, and I don't have to go too bonkers on that. And I'm just browsing through here. Of course, found clear evidence, risk protection period, not exceeding 12 months. Let's see what subsection 7 has to say about this. Surrendering firearms and ammunition. Pretty damn self-explanatory. So I just really gets my goat here at times. Sworn statements, yeah. So very totally illegit. I like what it says here about subsection 8, return and disposal of firearms and ammunition. If a risk protection order is vacated or ends with the entire extension, a law enforcement agency holding a firearm or any ammunition owned by the respondent or a license to carry or conceal weapon or firearm issues under statute 790.06 held by a respondent that has been surrendered or seized pursuant to the section must return such surrendered firearm, ammunition, or license to carry concealed weapon or firearm issued under Florida statute 790.06, which I say is supersedes, should never supersede your basic law, the right to carry under Article 1, Section 2 of the Florida Constitution. As requested by respondent only after confirming through a background check that the respondent is currently eligible to own or possess firearms ammunition under federal and state law. Interesting there, right? And after confirming with the court, the risk protection has been vacated, has ended without extension. That's A. So it tells you it's vacated, end without extension. This is B, the Department of who? Agriculture and Consumer Services. Got to give all that back, reinstate and all that, so get your privileges back. Government, can you carry my firearm, please? Okay, here you go, ma'am. Here you go. Thank you, master. May I have another? So something a lot of contradictions. Talk about transfers and reports of orders on here, which I don't have to really talk about. But it's really boggles the mind. What's interesting here about 11. A person who makes false statements which he or she does not believe to be true under oath is here under the section in regard of material matter commits a felony of the third degree punishable as provided on Florida statute 775.082, .083, or .084. So it could be perjury. B, a person who has his or her custody control a firearm or any ammunition, or who purchases, possesses, or receives a firearm or any ammunition with knowledge that he or she is prohibited from doing so by an order issued under the section commits a felony under the third degree, and the same statutes. And here's subsection 12 of it. Law enforcement retains over authority. This section does not affect the ability of law enforcement officer to remove firearm ammunition or to license to carry, conceal firearm from any person or to conduct any search and seizure of firearms for ammunition pursuant to other lawful authority. Okay, so liability. 13. Exceptions provided by Section B, Section 8 or subsection 11. This subsection 8 or 11, excuse me. This section does not oppose criminal or civil liability or any person or entity for acts or omissions related to obtaining a risk protection order or temporary ex par risk protection order, including but limited to providing notice to the petitioner, a family or household member of the respondent, and any known party may be at risk or failure to provide such notice, or reporting, declining reporting, investigating, declining to investigate, filing, or declining to file petition under this section. So interesting about that, huh? Something you gotta, bite your tongue supposedly, right? And of course, instructional informational material, which is brochures and all that, instructions and how to fill out the forms. Let's see here. Yeah, that's all mainly it, on how to fill out the forms. But when you really look at this, friends, this is an example. This Florida's risk protection orders is just another example of a Bill of Attainder. And it's interesting here because this whole Bill of Attainder originally started during the time of England. During Henry VIII, he used to do that to several people. And this one came from legaldictionary.net. This is something you should always look at. Definition, as I said, the term Bill of Attainder refers to the acts declared a group of people or people guilty of a crime and punishing them for it. It's usually without a trial. This is what as you can see with this whole RPO or red flag law in Florida. Many other states have it Same, very, very identical. Officials have used Bills of Attainder to strip individuals of everything from their property to their lives. For example, Bills of Attainder caused the famous execution of several people by English King Henry VIII. To explore this concept, consider the following Bill of Attainder definition. This is what it means. Now, a law that sentences a person or group of people to suffer punishment for a crime without being able to exercise a judicial right in defending themselves. All right? So it originally started from 14. This one actually started in late Middle England from 1425 to 1475. I'm not going to go too far. I'm just going to go to a few areas on this. But I will put the links on there, the website, so you can look it up for yourselves on this matter. And like it says right here, I'll read why the U.S. Constitution forbids the Bills of Attainder. The U.S. Constitution forbids the Bill of Attainder in Article 1, Sections 9 and 10. The ban extends both the state and federal governments. So this is right here. I'll continue on. I know I'm jumping back and forth. The fact that ban extends to the states shows us how important those who draft the Constitution believe this issue to be. The two main reasons why the U.S. Constitution forbids the Bill of Attainder. One, the ban reinforces the separation of powers by forbidding the legislative branch of government from engaging in judicial or executive acts. Two, the ban supports the concept of due process, one of rights attributed by the Constitution to every American citizen. Each individual state's constitution also forbids the issuance of a Bill of Attainder. For example, Bill of Attainder is forbidden by Wisconsin's Constitution in Article 1, Section 12, when it reads, "No Bill of Attainder ex post facto law, nor any law impairing the obligations of the contract shall ever be passed, and no conviction shall work blood of corruption or forfeiture of estate." And we can look at same right here of a Bill of Attainder, which is prohibited laws. Article 1, Section 10 of the Constitution reads, "No Bill of Attainder, ex post facto law, or law impairing the obligations of the contract shall be passed." And then we'll go up here to Section 9 of the same article. Due process. No person shall be deprived of life, liberty, or property without due process of law, or be twice put in jeopardy for the same offense, or be compelled in any criminal matter to be a witness against oneself. So, something to let that sink in to all those folks that support red flag laws and the people who are running for Congress and all that on a federal level and state. You're just letting everyone know you're going to be breaching your oath of office when you get in there. It's self-explanatory. You can't even refute it. I give people facts, they want to defend it. It's all hot air to me. Prima facie just cause should never be conquered with defense mechanized rhetoric. Hopefully I correct that. It could be the other way around. Defense mechanized rhetoric shall never supersede prima facie just cause. I'll continue on here about that. I'll just take it all the way to due process. Let's say separation of powers. The separation of powers provision divides the U.S. government into three branches: legislative, executive, and judicial. The idea is that in order for American citizens to enjoy the fullest extent of their liberty, these branches of the government must work together but have their own functions. The responsibilities each branch are as follows. All right, hear me out here. Legislative, this branch passes laws, budgets, the money necessary to operate the government. Executive, this branch, which includes the president, is responsible for enforcing the laws that the legislative branch passes. Judicial, this branch, which includes courts and judges, interprets the Constitution and applies the law accordingly. No judicial supremacy. That's why we got separation of powers. I will continue on here. The powers of all three branches intentionally overlap to promote the objective of all three branches working together to achieve a common goal. The division of powers also promote the concept of checks and balances. Checks and balances refer to the branches keeping each other in line so that one branch does not enjoy too much power. This is why the president has the power to veto a bill, but Congress has the power to override the president's veto. It's a way for the president to keep the legislative branch in line and for Congress to keep the president in line. Due process. The right of due process appears in the 5th and 14th Amendments of the U.S. to the U.S. Constitution. Due process refers to a person's right to fair treatment by the judicial system. Due process is in place to protect the rights of American citizens. For instance, the denial of a speedy trial for a person accused of a crime is a violation of his due process rights. He might sit for months or even years in a jail cell without having the chance to defend himself. Due process also protects citizens from physical abuse or other unjust acts committed by police, judges, and other law enforcement authorities. You're understanding, my friends. I know many of you out there do. Like I say again, Florida Statute 790.401. Risk protection orders are unconstitutional from both U.S. and state constitutions, for example, Florida. Many of these individuals out there who are in these positions claim to be lawyers and they assume they're smarter than everybody else. When you read these unique documents, it's very self-explanatory. You don't need a lawyer to figure it out. And this is why I support this. Anyone get their rights violated in these conditions, fight back. Which is, I guess, it's Title 42, U.S. Code, Section 1983. If your constitutional rights have been deprived, you can take them to court, sue them for it. Throw that at their faces, even on a state level, because the state's got to be in uniform with the federal powers under the U.S. Constitution, because Bill of Attainder and violating due process is illegal. Period. Now I was like looking through Federalist Papers number 84, which was by Alexander Hamilton, which was on the 20th of May, 1788, and it talks about Article 1, Section 3, Clause 7, and Clause 2, 9, and all that. And of course here, Section 9, Clause 3, no bill of attainder or ex post facto law shall be passed. And 8, no title of nobility shall be granted by the United States, and no person holding any office or profit, trust under them shall, without consent of the Congress, except of any present, eminent office or title, or any kind of whatever from any king, prince, or foreign state. I'll just leave it at that right there. But I like it when it says here, on the second page of this, when he made a little quote about I can say the second, third sentence here. The creation of crimes after the commission of the fact, or in other words, was subjecting men to punish for things which, when they done, were breaches of no law, and the practice of arbitrary imprisonments have been in all ages, and the favorite and more formidable instruments of tyranny. The observations of Judæus Blackstone in reference to the latter are well worthy of recital. This is, quote, to bereave a man of life, says he, or by violence to confiscate his estate without accusation or trial, would be so gross and notorious an act of despotism as must at once convey the alarm of tyranny throughout the whole nation, but confinement of a person by secretly hurrying him to go where his sufferings are unknown or forgotten, it is less public, less striking, and therefore more dangerous engine of arbitrary government. And as a remedy of this fatal evil, he is everywhere peculiarly emphatical in his encomiums on the Habeas Corpus Act, which in one place he calls the bulwark of the British Constitution. I'll just go one more paragraph, which is short. Nothing need to be said to illustrate the importance of the prohibition of titles of nobility. This may truly be denominated the cornerstone of the Republican government. For long as they are excluded, there can never be serious danger that the government will be any other than that of the people. Something to think about, my friends. Very intriguing indeed. Alexander Hamilton warned us about these things. So I recommend everyone take heed, read, share. Send these to your elected servants. Call them out on it. Put it on Twitter. Or send it to them in person. Bring this to a town meeting. The bottom line is this, my friends. This red flag law is nothing more than asset seizure. They call it asset forfeiture, asset seizure. Illegal. Just another example what tyranny is. And anyone who supports this can be indicted of treason. Article 1, Section 20 of our state constitution made that statement. Let them know. You're watching them. Because I'm doing it. And that is it. I'd like to thank everyone for listening. Plus, feel free to download and share us throughout your social media networks. If you have any questions, comments, or we said something that's interesting you want to check out, whatever you do, please feel free to send your comments with decorum. I will post these things on my show notes. You can just do a little search engine and read it for yourself. I'll try to put some of the links on here as well. All right? Once again, thank you for your time. Plus, always remember that demoniac resistance is healthy for the soul and can liberate humanity. Until next time, take care of yourselves. Keep on spreading the love. And may your guardian spirits be with you.